I am Alita Cass, Vice President for Strategic Initiatives at the Federalist Society and Director of the Freedom of Thought Project. I guess two big questions. Why is DOJ at the Federalist Society event explaining merger guidelines? And well, I'll leave the first question to you. The second question, I think, is even sort of maybe a bit of even more of a puzzle, is why is Freedom of Thought Project talking about merger guidelines? And I think both are great questions. I will not step on your question. For my question, I think it is actually a bit of a puzzle. I think generally, if you'd talked to me 5 years ago even, how we think about regulating, how law regulates business is really just like, please don't mess it up. Do not actually prevent business from making trains run on time. And in antitrust, maybe even more so. I think there's a sense that economies of scale are good and just sort of create positive effects. And yet, there is this other thread where you see just some kind of weird stuff going on. You see private institutions operating in ways that we maybe don't expect, whether it's in ESG or other forms of ideological coercive orthodoxy. It doesn't seem as the way that we might expect efficient business operations to run, and relatedly, we might wonder why competition isn't working in the way that we might expect. And so we have these two distinct threads, and sort of how we might assess and harmonize those threads is why we are here today, why it's freedom of thought, and why we have James Burnham to direct this conversation. I will let James introduce everybody and ask his great question. James is an attorney working in private practice in DC and is actually currently now
litigation finance now. Yeah.
Yes, now entering
2 weeks ago.
a sort of a brave new world of litigation finance. And so with that, James.
So I will confess I did not prepare elaborate introductions, but Jonathan is the Assistant Attorney General of the Antitrust Division, and Doha is the Principal Deputy Assistant Attorney General of the Antitrust Division, two of the most senior officials in the Biden Justice Department, who I assume are not, like I am, card-carrying members of the Federalist Society. And so I was just wondering, why are you here with me and my bow-tied friends to announce, the merger guidelines?
It's the quality of the chairs. You want to take it out?
Sure, and then you should chime in. Look, at the outset, I think we owe you, Alita, and you, James, a huge debt of gratitude. We take our public service mission very seriously. We take seriously the fact that the Justice Department is sort of the law firm for all Americans and not certain Americans, and we have an obligation to get out and talk to people. That engaging with folks sharpens our viewpoints and assumptions, and we're able to vet our ideas, and this is a really wonderful place to do it. And so, James, you're right, I'm not a card-carrying member of the Federalist Society.
I don't know if there's actually cards, but...
Well, if there were, I don't think I would have one. But that said, I always appreciate that you guys are willing to have people like myself, like Jonathan, who can engage with your audience candidly and constructively. So thank you.
I'll just add a couple things. First is, we issue draft guidelines for public comment. And this is a sincere process. We want to hear from the public. We want to have a discussion about the draft guidelines so that we can get that feedback, we can digest it, and we can make improvements as appropriate. And this is an important process. And it's important to hear from you and your audience as well as the public more broadly. Also, I was thinking back right over here, I think it was 2017 when I did my first talk at a Federalist Society event, and it was a panel about antitrust. And I remember it was kind of a remarkable experience because the theme of that discussion was rule of law. And so I started the discussion about, we don't think judges should be activists. We think Congress should determine the goals of law and write statutory text. We think the theme of that discussion was rule of law. And so I started the discussion about, we don't think judges should be activists. We think Congress should determine the goals of law and write statutory text. We think we should faithfully apply precedents according to appellate in the courts and the Supreme Court. And then I talked about how I thought antitrust had diverged from that, what I thought was a unassailable approach to applying the law, and that a lot of antitrust had become activist, and economics, important discipline used to address questions of fact, but ultimately questions of law should be directed by Congress and interpreted by courts. And now at the Justice Department, that's the approach we're taking. We're enforcing the law. We're doing it the way Congress wrote it and the way courts have applied it.
Okay, so I'm going to actually switch the order of these a little bit. So I went to the University of Chicago, and so I was inculcated in the Chicago school. I had Robert Bork on the nightstand, kind of gazing or glowering at me, depending on how you look at the photo. Easterbrook was walking the halls. And so I guess one question I have just kind of off the bat is, should I understand the guidelines or the draft guidelines as a repudiation of the Chicago school, or more an effort to pare back some of its excesses, the excesses that attend any revolution, perhaps? Or is something else entirely different?
Yeah, I'll kick it off and then Doha can jump in, but let me explain to you a little bit about how this process took place. It's not an exercise in ideology necessarily. What it is we looked at the law. We read every single merger decision ever since the beginning of the Clayton Act.
Actually, I'm sorry, I have to chime in because I think the audience might be a little bit suspicious of this. I was a witness to this. In fact, I was sitting in my office when Jonathan walked in and he said, I want every Supreme Court merger case and Court of Appeals merger case ever decided. And I remember when our staff wheeled in these binders of cases, and we did in fact read all of them. So he is serious about that.
And then we went down into the district court level, and we asked the question, what does the law say? What does the law say about mergers? How do courts interpret the statute as expressed by Congress? And then we work backwards from that. And that was the scaffolding. Those were the bones that we used to create these guidelines. And then we asked, well, what are the best, most state-of-the-art tools that we can use to apply the law and understand the facts on the ground and make sure we understand how markets function in a way that's relevant to today's economy? And that's how we drafted the guidelines. It wasn't about this school or that school. It was simply about what does the law say and how do we apply it in a way that's faithful to the language of Congress and the interpretation by the courts, starting with the Supreme Court on down.
I would only echo all of that. I would also say that we also undertook the exercise of assessing the legality of a merger without guidelines, which is the normal, for those of you who come to the world of law with not an antitrust background, you think about researching cases and figuring out frameworks. And the process of assessing the legality of a merger as though guidelines did not exist, I think also taught us very important things about potential divergence between guidelines that have existed since 1968 and the way courts think about mergers. And I can't help but pick up the last thread of your question about Bork and not Bork. Yeah. Look, I am...
Never Borg?
I actually worry hugely that the kind of Chicago school Bork, anti-Bork thing has become very reductive. And it's almost a shorthand for describing what you're for and what you're against. And I kind of reject the premise of the question a bit. I think that these guidelines are only a revolution insofar as you think that there is divergence that the antitrust agencies were engaging in that is different from the law.
Totally. So I should say, I should have said this before, it's a very impressive piece of work. I mean, you guys clearly put a ton of effort into this. I can't believe you read, how many cases? Thousands of cases?
Here's the thing.
Who's running the antitrust division?
Surprisingly, there are not as many cases as you'd think.
Yeah.
And that's part of the challenge, right? The last merger case, trivia question, when was the last merger case decided by a Supreme Court? Year. Come on, somebody here knows. Stoller?
1974.
No. American Stores, 1990, right?
1990.
Wow.
And so, but there aren't that many. And so when you think about, well, what does the Supreme Court say about the law, you have to cite to old cases because that's what exists. But these cases that we're citing to are cited by appellate courts and district courts.
Yeah.
The most recent merger decision was in a case we lost involving sugar. Why? Because the court cited to the brown shoe case 10 times, or over and over again, and the defendants cited to themselves 10 times in their brief, saying that we relied too much on the previous guidelines and this narrow economic test when we should have used practical indicia, as defined by the Supreme Court in the brown shoe precedent.
So that basically, I want to give you a chance to actually address this even more directly, although you mostly have. Some people have sort of criticized the guidelines for citing cases from like the 70s as if they don't count anymore. There's some sort of statute of limitations on a case. And I was just wondering, I mean, it sounds like the reason is that's when the law was decided that is relevant, but why don't you?
And I'll defer to Senator Doha in a second, but those are the same cases that are being cited by courts.
Right.
The Pabst case was cited in our Penguin Random House Simon & Schuster case. There's actually one case we did miss, I will say, which is the Anthem case, a case that the Department of Justice won in the DC Circuit. Finally, and before I send it to Doha, I can't resist. You know what's an old case? Marbury versus Madison.
We like that case here at the Federalist Society.
So, but if we apply the same rules that some of these critics are applying, then we should say that no longer applies too, because it is expired. Or is the argument against us that only antitrust cases expire?
Right.
But the principles in these cases are valid law, and as law enforcers, we should enforce the law as written by Congress and interpreted by the courts.
Yeah, and just again, nuance that I think is helpful for folks who are just starting to engage with these guidelines. You know, when we cite older cases, setting aside the fact that there just hasn't been a Supreme Court Section 7 case in about 33 years or so, and the last time the Justice Department was a litigant before the Supreme Court, I think was 1978. Jonathan, you were in elementary school, I think. You know, it's been a long time. But we cite these cases not because we endorse the economics necessarily, right? We cite them for legal propositions that are still good law. And the magic of antitrust, the reason we all love the practice of antitrust law, is that it's fact specific, right? And we bring all of our best tools of analysis, the very best of economics, the very best of other analytical tools to bear on these legal propositions to answer this remarkably flexible statute that simply asks whether the effect of a merger may be substantially to lessen competition or tend to create a monopoly.
So that, I think that's a good lead to my next question, which is obviously economic thought changes all the time and has changed a lot since the 70s when a lot of these cases were decided. I think some people would say that, you know, we now realize that business combinations very frequently enhance efficiency, they lower prices, they benefit the economy, et cetera. So what is your sort of, because the antitrust laws are sort of uniquely infused with policy judgments, because every merger is a little bit different, what is your answer to the critics who say, you know, this is going to impede growth, it's going to raise prices, pretty soon we'll be Greece, you know, all of that sort of stuff that I'm sure some libertarians are saying, perhaps in the audience.
So, look, all of these benefits that you've just described are the benefits that I would ascribe to competition, right? So this is not about we like business, we don't like business. Jonathan, I think I can speak comfortably for Jonathan. We happen to be very proud of a really dynamic, robust U.S. economy. We think it's a thing of beauty, and we think that the best thing to look forward to in our economy for the future is like a competitive, dynamic economy. You know, on the subject of a policy judgment, I think Congress was remarkably clear-eyed and stated the value judgment, right? Competition is the value that Congress elevated above all others in passing the antitrust laws. And so we don't have the discretion to depart from that policy judgment. So we can't say, you know, a business is going to do, you know, insert your favorite social benefit or whatever. We have to uphold and vindicate the value of competition.
Yeah, I couldn't agree more, not surprisingly. And that's the question you're asking, first of all, has a lot of embedded assumptions, which I think, you know, is an interesting academic debate. But ultimately, if people feel strongly that the law should allow certain kinds of mergers, there's a forum for that. That forum is Congress. You should go to Congress and advocate for Congress to write the law differently than it's written. But until then, we have the Clayton Act. The Clayton Act says a merger, you know, is illegal when the effect may be to substantially lessen competition or tend to create a monopoly. And so I think it's really important that we remain faithful to the statutory text, and at the same time remain faithful to binding court and relevant court precedent, starting with the Supreme Court on down.
Yeah, would you mind expanding on that a little bit? I mean, I think it's actually in our contract that we have to ask about text and history here at the Federalist Society. So you've already alluded to this a few times. I mean, could you explain maybe a little bit, because you know much better than I do, the history of these laws, you know, what the text actually says, because none of the court decisions tend to talk about, at least the modern ones, and how that plays into your analysis of what your job is as the enforcement folks.
Doha's great on this.
Okay.
Okay. Look, the legislative history of the Sherman Act is replete with sort of references to the value of competition, the concern about monopolies, not just because they drive up prices, they command the price of labor without fear of strikes, and like all these concerns about what happens if you have corporate power that's concentrated in the hands of a small few, or in some cases just one. You know, there's a lot, you know, it is dangerous to engage in too much, you know, sort of indulgence in the legislative history, but the one thing that we do know is that Congress intended to elevate the value of competition. So it passed the Sherman Act in 1890. Section 1 forbids contracts, combinations, and conspiracies that unreasonably restrain trade. Section 2 bans monopolies, attempts to monopolize, and conspiracies to monopolize. Fast forward to 1914, you know, this is going to be a trend. You're going to see Congress strengthen the antitrust laws. Every time Congress had something to say about antitrust, it gave enforcers, and in some cases private citizens, more tools to combat monopolies and companies that engage in anti-competitive practices. And so in 1914, we get the Clayton Act that has a number of sections, including Section 7, which is really the heartland of merger enforcement. But there's other important sections, right? Section 6 makes clear that the antitrust laws were not intended to be brought to bear against labor unions. Section 8 prohibits interlocking directorates. That's one of Jonathan's favorite. You know, fast forward to 1950, you get the Seller-Kefauver Anti-Merger Act. Then you get the Hart-Scott-Rodino Act, which gives us the power to review mergers before they're actually consummated, right? Before that, we tended to have to review mergers after they were already closed, and it's very difficult to unscramble eggs. It's difficult for courts to make those judgments. It's difficult for businesses that closed, you know, perhaps not fully appreciating the antitrust risks of closing. And so that's my, you know, 45-second, maybe 1 minute
You can have 30
survey
more seconds.
of the antitrust laws.
Yeah. So, okay, that's really interesting. And so one thing I was struck by actually reading the Clayton Act, which I had not done, is just how broad the language is. I mean, it would seem as though you're almost compelled to intervene in any time competition is going to be reduced in a particular marketplace. So, I mean, is there any more, and I don't mean to press on it if there's not more, but is there anything more about the historical context of the statute and the values that Congress was concerned about at the time that can help us understand what that means? I mean, is it all just about price, or is there more going on here, I guess, when the statutes are enacted that give them a much broader significance?
Right. And so this, you know, can be subject to interpretation, but I think it's important to focus on the statutory text. In the context of the Clayton Act, it's about competition and monopoly. Those are the concerns that Congress had, and essentially said we do not want mergers that risk lessening competition in a substantial way or tending to create a monopoly, and it was a risk assessment at the time. I think you can look at the history of antitrust and anti-monopoly and say that Congress and the public care deeply about it because concentration of power is just as dangerous as in corporate sense, it's just as dangerous as concentration of power in the government sense. And we don't want kings over the necessities of life, and or queens. And I think we have to be thoughtful about, you know, why do we care? Why do we care about having choice? I think about it from my own personal perspective, which is economic opportunity. The essence of the American dream is the ability to start your own business, feed your family, make your lives better for your children than it was for the generation before. And those opportunities come from the ability to live where you want to, work where you want to start a business and to have that business thrive. But if you don't have choice, if you don't have diversity of viewpoints in speech, if you don't have the ability to innovate and create new and exciting products, then we lose the essence of our democracy. And I think these are really important points that Congress used to animate when it wrote the antitrust laws. But they're written in a way that is clear about the value judgment that Congress made, the Clayton Act, Section 7, is that competition is important. We don't want to risk losing it. And monopolies are problematic, and we don't want to risk the creation of monopolies.
So I think that's a great point, and that actually leads to another question I was going to ask. I mean, one of the things that I think has shifted some sort of conventional conservative opinion is the sort of extraordinary imperiousness of corporations right now. I'm sure some people would say, I bet Matt would say, corporate behemoths have always been imperious. But I think some folks would say that nowadays dominant firms go way beyond core business functions regularly. They try to intervene in ways to shape our behavior, shape our ideas, dominate our culture. It's my longest question, but I'll be done in a second. Deployments of corporate power that have nothing to do with their core business purpose of making widgets and trying to sell good widgets at a low price. And so I think one explanation could be that that's the product of excessive consolidation. There are so few firms that they can now do whatever they want and dare their consumers to do something about it because they really can't. They really have nowhere else to go. And I was just wondering, and it sounds like you may think the antitrust role, whether you think antitrust law has a role to play in dealing with sort of the cultural effects of excessive consolidation or the societal ones.
Yes.
Great.
I think this is hugely interesting. I agree with you that there's more interest in antitrust because I think there is more concern about the power of large incumbents to shape different aspects of our life, not just sort of what you can buy and sell, but what you view, the news that you consume, and other sort of options and products and services that would be available to you. But I would challenge the notion that the antitrust laws haven't always contemplated those kinds of concerns. One of my favorite pieces of writing is Henry Demarest Lloyd writing in The Atlantic, and I think it's like 1888, and he's writing extensively about the misery of life under the Standard Oil monopoly. And so I think that Congress was clear-eyed about why we don't want monopolies in our country. And again, it's such a it's a really very beautiful point, this idea that there are ways that corporate power taken to its extremes can be as intrusive in American life as government power, which, as you know, our Constitution itself is a remarkable document that contemplates the dispersion of power, right? We have high regard for the separation of powers because we believe in our system of checks and balances, and we believe that it is conducive to preserving our liberty.
Do you have any thoughts on how kind of the conventional wisdom of what antitrust law is supposed to do got so out of whack with some of the values you're talking about? And I didn't give you that one in advance, sorry.
Yeah, no, that's okay. It's hard to say. I think it's a mix. I think there were attempts to impose rigor and predictability, and this belief that there could be a science to proving things with certainty. But I think, some humility demonstrates that that's not always possible and that it's not always required. The statute is a risk assessment. It's not a definitive proof statute. But I also think that we lost sight of the goals that Doha just articulated so clearly. Why do we care? Why do we care about competition? Why did Congress write this statute? And I think when we start veering from the statutory text and the case precedent, it's very easy to lose your way, and it's very easy to infuse values that might reflect your judgments rather than the judgments of Congress. And I think part of what we're trying to do is go back to the statutory text, look at the case law, and treat this as a function of law enforcement and rule of law rather than ideology. Policy judgments should be made by Congress. Now, inevitably, they're going to be, cases are going to be fact specific. They're going to be judgments that have to be made on the line and enforcement. But if you have a North Star, and that North Star is what are the goals of the antitrust laws as articulated by Congress in the statute and interpreted by courts, it's much easier to stay in line with that direction.
Yeah. So do you have any, and obviously feel free to reject the premise of the question too, but to the extent that the merger guidelines are sort of forward-leaning on kind of how antitrust law should be understood in 2023, do you have any concern that that could be in some tension with or undermine ongoing enforcement actions that rely on what I would view as very conventional theories of antitrust law that even, whatever, the biggest Borkian would say are plausible or good theories?
Yeah, let me start on this because I think it's really important when we think about tools, analytical tools that we use to enforce the antitrust laws, economics being the most notable, that we use those to address questions of fact, not to decide questions of law. Questions of law should be viewed in light of the statutory text and applicable precedent. I think it's undeniable that markets today are different than they were 50 years ago or 15 years ago. Competition is as important as ever, and the core principles of the antitrust laws still remain as relevant today as they ever were. We want choice, we want competition, we want diversity of viewpoints and ideas. We want all of these things. A merger shouldn't substantially lessen direct competition. It shouldn't entrench monopoly power. It shouldn't accelerate trends toward concentration. How we apply that is fact-specific, depending on each individual case. And I think we often get wrapped around the axle in antitrust around a very stylized model of competition as simply vertical or horizontal, which are terms that really antitrust lawyers and antitrust economists use, but business people don't. Why? Because it often understates the nuance of modern business and modern markets. I often say looking at things solely through a vertical or horizontal lens is like watching 4K video through a black and white TV. You might see the images, you might understand what they're doing, but you're going to miss all the nuance. And so we've taken an approach that actually uses more state-of-the-art economics. Our chief economist, Susan Athey, who's here, is one of the most revered economists in the world, Bates Clark Medal winner, and understands that markets are complicated and dynamic. And we use that understanding that markets can be multi-sided, multi-dimensional, and that competition can present itself in lots of different ways. And so these guidelines are built, designed to start with the important question: how does competition in this market present itself? And does the merger threaten that competition or threaten the creation of a monopoly? That's an important first question to ask, because if you can understand that competition might be in a very traditional way, like stores that are located across the street from each other, or a vertical supply chain where you have a manufacturer, a distributor, a retailer, that construct might apply. But you might have platforms, and you might have multi-sided markets, and you might have moats, and you might have distribution of ideas. You might have AI that is built on massive data sets. These are market realities that we have to take into account as we understand how markets work, so that we can apply these well-settled and well-established and quite sensible legal principles appropriately.
It's hard to improve upon that.
Well, I was going to ask if there's anything else you want to say, but that might be a good closing argument. So yeah, we can bring Todd up now to talk about what he's going to say, and then bring you back. Does that work? Or?
We look forward to that.
Awesome.
We'll shuffle over.
Great.
I'll shuffle over to the broken chair.
Okay. You did promise. We can get you one of the audience chairs. Would you like one of those?
No, that's okay.
Okay.
I was going to make a products liability joke, but I won't.
So, Todd, thanks for being here.
Sure.
I also did not prepare an elaborate introduction for you, but I know you're a very distinguished professor at George Mason University who knows a lot about antitrust law. So maybe to start, you could just kind of give us your overall take on the guidelines and what Jonathan and Doha said.
Yeah, I want to first congratulate them. It's a very impressive piece of work, not just in sort of what the recommendations are, but as an academic, I admire the craftsmanship and the research and the diligence that went into this. And one of the things that struck me most as I was reading it is that I'm sure this wasn't their goal, but it really does speak to the moment in a way we're in. And I think, hopefully this will put a smile on their face, I think that what they've done here is in many ways carved out a moderate position, a sort of moderate position between different camps, both among Federalist societies and conservatives on one side and progressives on the other, by which I mean within the Federalist Society, we've seen this emerging split that's to some extent generational between the kind of traditional sort of economic efficiency Chicago school guys that sort of was my generation, but a younger group, a more populist group, who in many ways, these messages are going to resonate with them. The idea that antitrust laws, competition policy writ large, not just antitrust laws, are about more than just low prices and efficiency for consumers. And the eagerness of many conservatives to, and state AGs, right, who have brought actions under the antitrust laws against social media companies and things like that. Obviously, it's not because they're concerned about consumer welfare, right, which is Twitter is free, Facebook is free, right? Google is free, right? Free stuff is free, right? So in some sense, whatever's going on there, it's not a traditional consumer welfare question or consumer prices, right? What it is I think the points that Jonathan Doha were just speaking to, which is that competition is a value in itself, and that concentration has risks associated with it. It has obviously economic risks that we may not see, not only in terms of actual concentration, but potentially deterring entry into a market, for example, which kind of the seen and unseen. The social benefits, right, to some extent, spillover effects of competition in small business, in those community benefits that I think a lot of conservatives, sort of new conservatives, are concerned about, and political issues, right, which is the political clout that these massive businesses have today. You just look at sort of Disney in Florida, right? They don't even live in Florida, and they're there basically going to dictate the terms of the democratic process to Florida, right? Because they're a big business that has a big market presence, right? And we see this all over, and there's an aspect of this, right? It's a lot easier for the Biden administration to pull off the stunt with the Twitter files when you only got to deal with Twitter and Facebook, right? More social media companies makes it harder to basically control speech, to use this overreach of the administrative state. And I think a lot of conservatives see this as platforms for competing speech policies, but also as a restraint on the ability of the government to overreach. And in some sense, you see sort of the same dynamic on the progressive side, where I think this also kind of hews a middle ground between sort of bringing in these ideas of competition, but also thinking about economics, thinking about how you weigh economics in the balance. And so we have our friend Matt Stoller here, who probably thinks this is, just a sellout to the corporate lobby or something.
He promised to say nice things.
He promised to say nice things.
That's how he got it
right? But those who are kind of even pushing the Brandeisian line even more, the worthy dealers and small dealers and worthy men. But then there's this kind of disconcerting, to me, comfort that a lot of progressives have with bigness today, right? Precisely because they can put the boot to Twitter, right? And Elizabeth Warren hardly even hides the ball on this, right? Basically, play ball with us, or I'm going to come after you, right? With whatever regulatory powers I have, right? Banks, right? They like a big consolidated banking industry that doesn't have a lot of small competition and that sort of thing. And Dodd-Frank, either intentionally or unintentionally, has led to consolidation in every single industry that it's touched, right? And I don't see Democrats being concerned about the way in which Dodd-Frank continues to make the big banks even bigger and to entrench too big to fail. And apparently now even medium-sized banks are too big to fail and get bailouts as well, right? And the whole ESG racket is basically an antitrust racket, right? Which is, the idea here is we'll adopt all these expensive, stupid policies. And typically in a market, if you adopt stupid policies like all this green energy stuff, you get punished, but not if you can basically have a consolidated industry. There's a reason why the Business Roundtable is all into ESG, right? Which is the big guys basically can virtue signal without having to be worried about competition and having it be undercut. So I think there is a sense here in which what they're doing is speaking to that moment, and I applaud them for trying to make this tractable. And I do think that they are correct about the political history, right? The original understanding here, which is competition and all this stuff was clearly part of it, right? And Bork may have been a great lawyer and a brilliant man, but I think the subsequent research has suggested he wasn't a perfectly accurate historian in terms of the legislative history about consumer welfare. Tom Hazlett's looked at this, George Stigler's looked at this, and others. And I think these virtues, these values they're talking about are in there. And I think we're seeing a moment now where people are trying to recapture some of these things. And I think they're actually giving a template here for recognizing those political, social, economic values that were part of the original Sherman Act and then kind of went out of favor in the 1970s and 80s for various reasons.
So there's a lot in there to unpack. So let me actually start with something that just kind of takes the Chicago school on its own terms. I mean, are there any examples, and I won't ask you guys this for all kinds of reasons, but in your view, of consolidation that has happened in the last 30 or 40 years that was just obviously bad? Airlines come to mind as they cancel flights constantly and the service is terrible and you don't even get the peanuts. But they were just clearly bad, even by the Chicago school's terms, but because everyone was sort of enamored with the idea that business knows what it's doing and how dare we interfere, nonetheless were allowed to happen.
Well, I don't think that's a fair characterization of why
people are saying.
Yeah, right. Yeah, people are saying, right? So they accurately describe sort of the state of law in the 50s and 60s. It coheres with what we saw, I think, during the early days of antitrust and the like. So what happened? Why did we change direction so radically in the 70s and 80s? And I would say what happened was reality happened, which is there are costs to a process like this where you're weighing multiple variables. Congress, I'll grant the point, Congress says you're supposed to do it, but there are actually costs associated with that, right? And so what we did was we woke up in the 70s, and what did we see? We saw high inflation, we saw high employment, we saw stagflation, and the big thing we saw was declining global competitiveness, right? And we looked out at the world, and what we saw this triumvirate of policies that were identified as being the problem, which is regulatory policy, right? And we have to remember, Jimmy Carter and Ted Kennedy and Stephen Breyer were the champions of deregulation in the 70s, right? They were the ones who, it's during the Carter administration that we started the process of deregulating airlines. We deregulated trucking, right? Why? Because these regulatory structures had basically turned into big cartel enforcement mechanisms that were good for the incumbents, good for the labor, bad for the consumers, right? I took one flight when I was a kid, right, because it was so expensive. It was a really nice flight. We went to Disneyland from Texas. I remember they had a cocktail lounge in the middle of the bar, right? I mean, it was pretty sweet. I don't know how my parents did it, right? Because they basically, the planes were flying half empty, right? But we had regulation. We had labor policies that were creating a lot of labor market stickiness and sort of lack of dynamism. And a lot of people said the other thing we had was problems with our competition policy. That, in particular, this focus on protecting competition is a double-edged sword. And if you look at the legislative history, what you see is a double-edged sword. Yes, it's protect competition. But what you also see when you look at Stigler, when you look at Hazlett, when you look at Gary Leibkap's great article on meatpackers in the Sherman Act, if you're familiar with that, when you look at Don Boudreaux's work, what you see is this was just small business basically protecting themselves from more efficient big businesses under the banner of competition, which was really we can't compete. Libcap's article is the classic, right? The local meat packers who couldn't compete with Swift and the refrigerated boxcars that could deliver fresh meat to people very, very inexpensively. And so the response was, well, yeah, there's a cost to this, and in global competition and everything else. The last thing I'll say, the other thing that was the other side of that is once you have these multivariate ends, there's a lot of studies at that time also that show this was a public choice nightmare, right? This was rent seeking out the wazoo, right? Which is, we talk about the rent seeking. The law itself was the product of rent seeking under the guise of competition. But what we see is there's these studies by McChesney and Higgins, I believe it was, Baumel and Ordover, Bob Tollison wrote some articles, right? These articles showing the way in which public choice dynamics were part of this, in particular, Congress intervening in the merger process to protect jobs in their own districts, to protect them from mergers, right? And there was just a lot of rent seeking going on. There was a lot of congressional intervention going on. You can look at all these studies. And they were very aware of that in the 70s. And so if you look at it, what they see is refocusing purely on the consumer welfare standard in some part was a vehicle for making the process more transparent and less subject to these political dynamics.
So I think I have just two more questions, then we'll just kind of let you guys talk. The first is just, you talked about the costs of the 70s and such, and I think it's hard to argue with some of that history, but do you think there's an argument that things have gone just way too far, or at least somewhat too far in the other direction,
right,
and that something like these guidelines is necessary to kind of recalibrate us to something approaching like what is actually optimal?
Yeah, and that's my point, right, which is for at least a political consensus has emerged that we have gone too far, right, with respect to these things. And again, I want to bring it back to the focus, which is why we are concerned about Twitter, why we are concerned about Facebook, why we're concerned about big banks and all this sort of stuff. Really, I mean, to some extent, it may be economics, but I don't think it's really about the economics. I think it's about the things that they're saying. And we can always kind of quibble about the economics around the margins. They've got some things here. But what they're really doing here, I think, is a very powerful insight. And this is, I think, the nut of what they're doing with the new merger guidelines. It's just that they're flipping the presumption, right? They're not going whole hog towards sort of all-out populism, right? And sort of jettisoning economics completely, right? Because that's kind of a problem we have right now, right? I mean, look at this idiotic thing, the Credit Card Competition Act of 2023, which I wrote in the Wall Street Journal, right? A complete misunderstanding of competition, complete lack of any understanding of the impact on consumers from this. I mean, it's just like, Roger Marshall and J.D. Vance are, co-sponsors with Dick Durbin and Peter Welch, right? Kind of thrown in with a kind of populist mindlessness that basically has nothing to do with economics. That's bad, right? I think the point is thinking about Twitter and these other things as purely economic questions. That also is not quite right. And so what we're seeing here is, and I commend them for this, is they're putting the issue on the table, right? Which is, how do competition is not just an economic value in the American psyche, in American history, right? Competition has always been symbolic. Competition has always been part of our fabric of the capitalism system, but also sort of democratic capitalism. And I see them, I think, to their credit, trying to reintroduce these values into things and sort of think about the in an economic sense, think about the intangible values of competition, of in sort of the unmeasurable kind of things that I think they accurately pick up in the economic history and the legislative history, which is we want to preserve competition as the competitive process, and not these sort of static equilibrium models that are sort of the warp and woof of modern merger theory, and trying to reintroduce this back into the scale. And so I think in some sense there is a sense in which it's a legitimate criticism of the Chicago School Revolution that it has gone too far in formalizing and systematizing and kind of stripping that value, that sort of social kind of political value out of how we think about competition in the competitive process.
So that actually took my second question already. So please, anyone, Jonathan, Doha, do you guys want to respond, say anything, or I can just come up with more
Go
questions?
for it. Yeah, I mean, that's a lot to digest. I was really thoughtful, and I guess I would offer a couple reactions. One is, I think when we undertook this project, we tried to do it without, by using the values that Congress itself laid out. And I think by doing that and using the case law, it gives us a structure to help make sure that we are staying on a path that is consistent with the objectives of the antitrust laws. You talked a bit about some of the articles and some of the concerns that came up in the 70s and around that period and subsequently. But I think one of the criticisms I guess I have of those criticisms is that those are value judgments. Those are ideas, right? And we can agree or disagree about those ideas, but the proper place to incorporate those ideas is Congress. And so if there's a belief that we should be using a different framework, then I think the proper place to do that is to go to Congress, get Congress to revise or issue a new statute, and then we will enforce the law accordingly. But until then, I think we have an obligation, certainly at the Department of Justice, to enforce the laws written by Congress and to follow the facts in the law wherever it leads us. And that means applying precedent. And if people are unhappy with that precedent, then again, they go to Congress and get repealer statutes. This is a process for that. But I think we have to be vigilant and diligent in making sure that we are being rigorous in our legal analysis and then using state-of-the-art tools to apply the law to the facts as we find them today, not as perhaps stylized models or I think what Doug North used to call blackboard economics would suggest.
Right.
Yeah, I mean, Todd, what do you think about that? I mean, conservatives, one of the big criticisms of the administrative state, of Chevron, of a lot of these doctrines is just executive branch people making stuff up. So why is that not a pretty good point, that when the economists and the executive branch people get together with a few of the judges and make stuff up, it's the exact same thing that we normally would be very unhappy about?
I think that's exactly right. And to tell the truth, and I didn't, I kind of got rolling and didn't clarify, right, which is, I think the case that, that the antitrust laws, by their nature, embody the pure consumer welfare standard, right? The Bork argument, I think, is just not correct. I think that what they're describing, and it could be different amounts of weight on different sides of the scale, right? I mean, every law is Baptist and bootleggers, right? Competition, protection of competition easily can become protection of competitors, right? Regardless of their efficiency. Both of those things are in the antitrust laws, which is incumbents who wanted to be protected against more, more efficient new rivals, as well as protection of the competitive process just generally. And so, but I think Johnson's exactly right. I'm not going to that I think what they have done is a fair reading of the antitrust laws. I think it's arguably an accurate reading, and certainly it's a reasonable reading. And when I look at this and when I look at that literature, I think, what do you say? It's in there, right? Which is, we may not like, I may not like rent-seeking laws, but if it's a rent-seeking law, it's like that's what Congress passed, right? And legislation are bargains and that sort of thing. And so, so it's two sides of the same coin, right? Which is, I agree completely. Competition is a virtue, right? I agree with these critiques that says that competition have social, political, economic values that transcend pure consumer welfare. And I think Congress says that. I think most Americans actually believe that. How you weigh that in the balance, Congress left open, and I applaud these guys for trying to come up with some way of reintroducing those values. And like I said, I think this is really a kind of a moderate position that really tries to reintroduce those values without kind of going whole hog in one direction or the other. So I don't disagree with them at all on that assessment of the law.
I think Todd's critique is very interesting. You know, a few times we've talked about concerns about lobbying and rent seeking and protecting less efficient competitors and things like that, and some of the older case law. And I guess I just quibble with the idea that competition is synonymous with those things. I don't believe that it is, and insofar as that was happening, I think it was a problem with the analysis and not a need to, or anything that would justify revisiting the goals of the competition statutes, which again are articulated by Congress and clarified by the highest courts. And, you know, I'm also deeply uncomfortable with the idea of the executive branch kind of reimagining those goals and recalibrating, you know, justifications for the application of the law or the lack of application of the law. I mean, I find that very concerning.
And I'll say, that's one short.
Sure.
Something you said I thought was really interesting. So how many, I mean, maybe you thought about this, the sort of bad antitrust decisions, the ones that people think are crazy, were they bad law or were they just really bad factual analysis? Where the court just garbled the economics and didn't know what the heck they were doing on the factual side?
So this is so important. I'm sure Jonathan's going to have some things to say about this. When we cite older cases in the draft merger guidelines, they're for propositions of law, right? There's a whole explanation in the draft merger guidelines about how we would not necessarily endorse the economics of the time. We feel incredibly fortunate. Jonathan went out and found us Dr. Susan Athey, who's an incredible economist and who makes us better in our understanding of what good economics can do. Right? Good economics can help us understand facts and apply them to those important propositions of law. You know, you might quibble with the fact that Procter & Gamble is cited in the draft merger guidelines. Again, maybe we wouldn't endorse the economics of that case, but it is a really important proposition of law that a merger should not entrench or expand the merged firm's monopoly power. Right, and we have tools to assess facts and tremendous prosecutorial discretion to determine whether a merger that may be notified in the future sort of violates Section 7 under that theory. And that, again, says nothing about the facts of Procter & Gamble itself.
I was going to just clarify. I just want to amplify what Todd said, which I think the argument that the antitrust laws compel the consumer welfare standard is a legal argument is exceedingly weak. So I just want to make it very clear, which is I think the reaction was the reaction I think was driven by a perception of the effects on the economy and globalization and global competition and that sort of thing. And so they kind of, I think they kind of skipped this. They skipped the step of doing the rigorous historical and original argument here. And so I think in that sense, I want to again commend what they're saying is I think largely correct as a matter of law.
But just so I mean, you all would say I think that everything in here is justified just under the consumer welfare standard itself, right? And then maybe there's broader values that are relevant, or I don't know. What do you think?
I guess I would start by saying which consumer welfare
standard?
standard.
Yeah, right, okay. Yeah.
Right, because I always like to say if you ask 5 lawyers what's the consumer welfare standard, you get 6 different answers.
And they have to check with the economist.
Yeah, and then you get 7 different answers, right?
Yeah.
And there are a lot of different interpretations, and I think if some people don't agree as to what something is, it's not a standard. And I think there's danger in that, but I think that's kind of beside the point. We did not need to get into that doctrinal debate here because we simply wanted to apply the law as written by Congress and interpreted by courts. And we did so in a way that we believe is faithful. Again, we look forward to comments, and this is a serious process. And if people believe that we misinterpreted a case or failed to apply another case, we want to hear. That's why we're opening this up for public comment. But we are trying to remain faithful to the law. Let me also just pivot a little bit, but I think competition is, I often like to say it's not a switch that you can flip on and off when you need it, right? I think Congress was wise by saying that we had to protect competition and against threats to competition in their incipiency. And I think a lot of people now see in their daily lives areas where they feel like they are victims of monopoly power or a system that doesn't have enough competition. I think the pandemic demonstrated that when supply chains got clogged and people had a hard time getting goods because output was constrained and there weren't enough people supplying it. Prices went up and they didn't have choice the way they wanted to. Now, we can all debate the economics of that, but I think, to bring things kind of back to the pragmatic, one of the reasons I think there's such a vibrant discussion of competition policy and rethinking whether our approach to the antitrust laws, or at least revisiting the cases in the statutory text for the original intent, is because people believe that it affects their lives. Mm-hmm. And different people have different views as to the value of competition. And that's okay, right? I don't have to share Todd's view. He doesn't have to share mine, and Doha might have her own view, and everyone will think there's a different benefit. But that's why the statute, I think, was wise in saying that the value itself is competition. And if we focus on that, then all the attendant benefits that flow from vibrant competition that lead to a better, more democratic, open, free society can flow. And that's what we're trying to protect. These guidelines are designed to be faithful to the statutory text in the law, but we're really eager to engage with the public to understand views, and if there are ways to improve them, we plan to do that.
If you don't have anything else, I think we have a lot of pretty smart people in the audience, and there is a microphone. Alita, I don't know.
I'll just add
oh, go ahead, Todd.
one thought
please.
on that. I think those are very, very insightful comments by Jonathan. It strikes me when I look back over the history of the last couple decades, the whole question of competition in many ways boiled down to this question of predatory pricing, right? Which is, so for decades, the answer is, oh my gosh, Walmart is going to drive out all the competition and then jack up their prices. It's right. Somehow or another, every time I go to Walmart, the prices are even less than the time I was in there before, right? So whatever's going on there, right? Everybody thought the concern about Walmart or an Amazon or whatever was predatory pricing. It appears, and so part of the argument was, well, that never really occurred, right? They never got to the recoupment part of it. And so I think, to Jonathan's point, there was a sense in which, well, if we get this wrong, it allows merger to go through and they start raising prices, it'll be entry and, all this sort of stuff, so it's no big deal. And I think what you're putting on the table that I think is an important point is, a really important point is, that's not really the only issue we're concerned about, right? It's not like, we're not concerned that Twitter is going to get a monopoly and then jack up the prices, right? I guess $8. I don't know if you consider.
I have not
the
paid.
price. Neither have I, right? But I think the point is that I think what I read in the guidelines, that defines the question too narrowly, right? It's not really just about predatory pricing and recoupment. That there's these other values that are associated with it that are important, and to the extent that we focused it narrowly, that's the sense in which you think about in terms of narrow consumer welfare standard, not being expansive enough to kind of meet the moment, I think that a lot of people are concerned about.
If you want to respond, please.
Please.
Go for it.
No.
I don't have a response.
We can also just ask
I'm ready for
No, it's
questions.
yeah, listen, I think, again, it comes down to competition. That's the value, right? And that's the value that Congress articulated. And again, the beauty of it is that it has all sorts of benefits. And so, if we want a free and democratic society, we need opportunity, and competition is the beating heart of that opportunity.
Awesome. So I just asked that they be questions and not debates. If you want debate, you have to buy them a drink at the reception after. Please, go ahead.
Hi, John Vecchione from the New Civil Liberties Alliance.
I'll buy my own drink. Just
fair enough.
Yeah, exactly.
I meant Todd.
There'll just be a buffet of drinks, right? No, but
you can buy me a drink even if if you don't want to debate me.
So my question is really not an antitrust question. It's more a rule of law question.
Yeah.
Will these guidelines, and I've only read about them, I haven't read them, so I apologize for that. The other elephant in the room is the FTC. And sometimes justice and the FTC aren't on the same page, which is somewhat, if you like, the unitary executive, and also if you're trying to be regulated by one law, that's sometimes a problem. Are these guidelines being put in place and all this work going into it because both agencies are going to be driven by them?
Yeah, so if I may indulge, Todd or James, literally on the same page.
Yeah, that's DOJ, that's the FTC. And there's a little White House, but you can't see it. It's cut off.
No. So this process was undertaken by both agencies because that has been the tradition at least since I think 1982 or 92. Before that was just the Department of Justice. And given the overlapping jurisdiction, I think it's very important that we drive to harmonization and convergence. And so, but when it comes to at least the Clayton Act, we're enforcing the same law and we're interpreting the same cases. And so that's makes it a little easier to get on the same page if what we're expressing is a faithful recitation of the law. And again, people can agree or disagree whether we got it right, but that's the goal.
So just a little bit more on rule of law principles. I feel compelled to say that the guidelines are not law.
Yes.
Right. The law is the law is the law. Right. The statutes are the law. The courts interpret the law. The guidelines are our best effort to be transparent to the public about how we think about merger review. Certainly, courts have relied on guidelines as persuasive authority, but again, the guidelines are not law.
Right. Yes, I completely agree with everything Doha said. It's an important distinction.
Hey guys, Satya Marar from the Mekki Center. I quite like what you said earlier about how America used to be about being able to start your own business, not rely on the man, support yourself, your family, and so on. One of the biggest barriers that small businesses face, and something that's one of the many things driving consolidation, one of the major ones, is cost of regulation. Very high fixed costs, often forcing companies to vertically integrate so they can bear those costs, and we see that in the impact of that in sectors like healthcare and even banking. So I know the DOJ has had a limited advocacy role in the past of researching how markets operate and what's driving or not driving competition. Would the DOJ consider returning to that role and investigating, doing a cost-benefit analysis of regulations' impact on the economy, as we looked at the 70s, and how it might be impeding competition?
Yeah. So let me start, and Doha can take it out, add on, which is that, first of all, our role at the Department of Justice is limited. It's limited to law enforcement, and so that's our focus. And we enforce, at least at the Antitrust Division, a very limited set of laws. And but we do often weigh in on policy. I will say I think the Competition Council and the executive order that asks agencies across the government to think about competition in a whole of government approach helps foster the importance of competition. And I think there are ways in which that's starting to work, but I think it's a wonderful thing when agencies around government are thinking about competition policy as part of their everyday practice.
Yeah, so agree with all of that. I would love the budget to have a whole arm to think about these kinds of issues, but our role is limited and our resources are limited, and so we can't do that. But what we do, as Jonathan mentioned, is sometimes provide technical assistance on the competition implications of proposed regulations, proposed rulemaking, for example. It is a pretty normal part of our practice to run into the regulatory regime, and while we may have our thoughts about individual regulatory regimes, our job is to enforce competition within the confines of the regulatory regime. And fortunately, there is very good black letter law on exactly that notion, right? That a regulatory regime is not a substitute for competition.
Yeah, and it's a good point, right? As I said, I mean, in the sort of the catalyst for the changes in the 70s, I think it was this combination of regulation and competition together. And a lot of, I think, this consolidation we're seeing now is actually downstream from regulation. Financial services being an obvious example. Healthcare, post-Obamacare, all this sort of stuff. So it's kind of downstream, and so there's a sense in which it's treating a symptom to try to preserve competition where it remains. It's a valuable mission. But I think your point is, if we want to think about competition writ large, treating the symptom and mitigating the symptom isn't enough unless we kind of go back and look at the underlying what's driving a lot of this.
So I got a couple of questions. In terms of the process of putting these merger guidelines together, you guys got a bunch of comments from the public, and I'm wondering how that was incorporated into the process of developing these guidelines. And then the other question I have is, do you think these guidelines will be, like, what's the intent of these guidelines vis-a-vis state enforcers? Because that was a big dispute in 82, 84. Would state officials who were bringing cases, would they adhere to the new guidelines in 82? And I'd be curious, Todd, to hear your view of how you think about state officials and antitrust, and if that's different than at a federal level.
So I loved the guidelines engagement process. So we put out an RFI, it was a request for information, and got more than 5,000 comments, which was really staggering. I think in 2010, there were 32 public comments. And we had a chance to reflect not only on the written comments, which our amazing policy staff actually read through every single one and condensed them into this amazing but dense binder for us that they summarized, and that was really illuminating. We also had engagement sessions where we heard directly from members of the public. And I'll tell you what that did. I think, we are lucid to sort of traditional antitrust harms, right? My prices went up, there are fewer jobs, et cetera. But I was moved by accounts from emergency room physicians, for example, who talked about, after a merger of their provider group or an acquisition by a hospital, that they were actually not able to provide as good care under the regulations or rules or whatever that were promoted by the acquiring company. There were accounts of maternity ward nurses that said, after a merger, they reduced the number of nurses on a hospital floor, and they were rounding less frequently, and they found that very stressful because they felt like they weren't able to deliver care. There were many more examples: agriculture, media, other really important industries in the economy, but hearing real accounts of how regular people, many of whom are outside the Beltway, experience life post-merger was very interesting.
I guess I'll add on that and say we were moved by that in a number of ways. One is making sure that these actually address the kinds of problems that people are confronting on a daily basis. And it also reiterated to us the importance of making these accessible to the public. And so antitrust has become, over the years, very technocratic. And the process of making it technocratic has made it exclusionary. And so it's harder for the public to participate in the process if the words that we use are overly complicated. Now, of course, nuance is necessary and sophistication is necessary in some instances. But we've hoped we found many ways in which we can make it more readable, more accessible, more usable. And I think that is a good practice for the agencies to pursue going forward, because these are the people's laws and we need to make them available and accessible to people. In terms of state enforcement, it's a great question. I'm curious, Todd, what you think. I'm always struck by the fact that state antitrust enforcement predates federal antitrust enforcement. And there are a number of state constitutions that actually have anti-monopoly principles in their state constitutions. These are like founding principles for states. And if you think about the principles of federalism, I think the states are co-equals and they have antitrust enforcement authorities, and we respect that and we work closely with them, but they have to make decisions that are independent. In terms of what the guidelines mean, I guess I'll defer back to what Doha said earlier, which is the guidelines aren't the law. The law is the law. And so to the extent that states are enforcing the Clayton Act, then if these guidelines are a fair recitation of the law, then I think it's an accurate recitation for anybody who's bringing a case. But ultimately, it's up for Congress to decide what the law is, or a state legislator to decide what their law is, and then for those cases to be brought based on the facts and the law to courts.
Yeah, I'll just say two things. First, on Doha's point about the nurses and that sort of thing, which I think is an important point, which is, by and large, as you can see, I'm favorably inclined toward the project that they're doing here. And a lot of the devil's in the details on how this is going to work out. I think will be interesting to see over time in terms of an experiment in some sense, a kind of a return back to the future kind of thing. When I was reading it, the labor recommendation was confusing to me, and that's one I think is going to take some time to kind of figure out and sort out exactly how that plays out in terms of cost of labor and that sort of thing, because there does seem to, in some sense, it's easy to see in a situation like that a potential trade-off between quality and cost, right? In terms of number of nurses and that sort of thing. It would be an empirical question in any given case, right? But, for example, cartels are great for labor, right? Labor loves cartels, right? That's why labor prospered so much when regulation in the 60s and 70s cartelized all these industries, right? It was great to be a pilot or a flight attendant or a truck driver or whatever, right? And so, kind of working out that, kind of how labor fits into this. It's a section in there. I think it's worth thinking about. I think a lot of people, it'll be interesting to see what they do with that. With respect to the states, I have to say I'm a bit of a skeptic. And partly, Don Boudreau's article on antitrust policy before the Sherman Act, where he looked at the states. Competition policy, I think, especially nowadays, is fundamentally a national thing, right? It's a national market. And I just think the balance between state enforcers protecting inefficient competitors from interstate commerce is so tempting. That's what Boudreau documents, was the origin of these early antitrust laws, was basically for small, in-state businesses to protect themselves from interstate competition. I see personally very little value added from an aggressive state antitrust enforcement mechanism, and a lot of risk of rent seeking from in-state interests protecting themselves from competition. And so that's obviously a broad generalization, but by and large, I tend to be relatively skeptical about what state enforcers are adding to this mix.
I just have to respond to the labor point. It's part of my
Yes,
contract.
You were mentioned in the comments, you get to respond.
Yeah, no, please, because I'd like to hear more on on that part of the report. Yeah.
Look, I'm always suspicious of sort of overly simplified notions of labor's ability to get protections from competition. Look, there are few instances where Congress actually subordinated the value of competition in favor of other policy goals, and one is labor. Right, Section 6 of the Clayton Act declares that the labor of a human being would not be subject to the antitrust laws, and I think that's very important. And there are, examples of courts actually building out that doctrine and giving us a non-statutory labor exemption as well. But labor competition is a really important part of the industrial relations of firms. Right, this is, I think, not very. I guess radical, right? We won a whole labor market merger challenge in Penguin Random House, Simon & Schuster, before these guidelines had seen the light of day, and we're really proud of that, right? We think that that case, that theory, was defensible under prior interpretations of Section 7. But when we talk about healthcare consolidation that leads to lower quality, right? We're often told consumer welfare is supposed to protect non-price dimensions of competition as well. And so I wouldn't sort of discount that or regard the 2023 draft merger guidelines as doing anything new. What they do is get crystal clear that labor markets are a type of input market, right? And while I think sometimes the economics of labor markets can look a little bit different from product markets, there's absolutely symmetry in the law in terms of protections for output markets and input markets.
Please.
Hello, I'm Waverly Wentworth. I am a law student, so please please go easy on me, even if my question does not go easy on you. So many are saying, by which I mean one Reason article, that the goal of these new guidelines is to deter any mergers going forward, to put a suppressant on the industry. What would you answer to those criticisms?
No.
Okay.
Go ahead.
So I have the great privilege of doing a lot of different things at the Antitrust Division, and I get to supervise the civil enforcement program. And so I see the statistics every single month about the HSRs that are filed. And so faithful to your request, I will go easy because you are a law student.
It was
Many
Reason's
mergers.
fault, not
It was
her fault.
Reason's
Yeah,
fault.
it's okay. Look, in our regime, a lot of mergers have to be notified to the agencies before they close, and they're subject to a statutory waiting period. And every single month, the vast majority of mergers go through without so much as a phone call from the Justice Department or the FTC. They go off without incident, and they close, and people move on with their lives. A tiny fraction are subject to a preliminary investigation. An even tinier fraction get an administrative subpoena called a second request. And the tiniest fraction are ultimately challenged in a federal district court or abandoned after we tell them that we have competition concerns. I think in fiscal year 2021, we got north of 3,000 HSRs. How many merger challenges did we have in fiscal year 21? 10 or so, I don't. And that was, I think, more vigorous antitrust enforcement, right? Like that was like a notable period for antitrust enforcement. And so I don't think that a faithful observer of what we were trying to do can reasonably posit that we were trying to deter all mergers.
I'll be a little snarky in my response, not to you, but to others, which is that I am often I'm often noting how the people who will criticize us for lacking rigor will lodge criticisms that are so devoid of any rigor. And I think, we are here because we want to engage in a rigorous, substantive, meaningful dialogue about how to interpret the law that Congress wrote and that courts have interpreted. This is a serious exercise from serious people, and a lot of the criticisms I've seen just are not fundamentally serious. And if there are legitimate disputes and questions, I think we should engage with those, and I welcome that, and I appreciate you being here as a law student. I think it's incredible, and I think the interest that I've seen from law students in these issues has been inspiring to me, and I think a lot of the greatest questions and insights in the field are coming from people like you who are in law school, who are curious, who are looking at these ideas with fresh eyes. But I think we want to have a serious conversation about serious issues, and I do think ad hominem attacks sometimes from the outside can be very attractive in a sentence or two. But I think what we're trying to do here is fundamentally more serious and I think more important, which is to get it right and have a good, serious debate about the law. But that was a great question, and thank you for being here and having the courage to ask it.
And I'll just amplify what Jonathan Doha said. That is not an accurate or fair criticism. That's totally off base for two reasons, which is first, Section 4 still talks about rebuttal evidence, right, in terms of failing firms and efficiencies and all that sort of stuff. That's all still there, right? They wouldn't have a section on rebuttal evidence if they just meant to block all the mergers, right? But the second thing I think is more important, and if you take one thing away from sort of thinking about this, and again, I keep coming back to this point that this is kind of a moderate document in some sense, considering all the froth and things that are going on in the political discourse around this. Things which is what they really are doing here is just changing the presumption, that there is, rather than, sort of type 1 and type 2 errors being reversed a little bit. And they make this clear on the first page of the merger guideline report is that, that the presumption is in favor of competition, right? I don't remember exactly, I don't remember exactly how they say it here. There's somewhere in here they've got the exact line, right? But basically here it is. To show that, that its effect may be to substantially lessen competition, right? And so that's really what's going on here, right? Which is what is the burden of proof on approving a merger or not approving a merger? That's a lot different from saying they're going to just block all the mergers.
Well, and that's a quote just from the Clayton Act, right?
Direct quote.
Yeah, right. Yeah, right.
So,
Yeah, no, but that's exactly right. We started with the law. It's not that novel of an approach.
Yeah, right.
Joel Thayer with the Digital Progress Institute, and really appreciate what you all have done on the draft guidelines. I do like the idea of going back to more of a textual analysis of antitrust instead of just a strict, almost staunch adherence to economics. Not to say it's not important, but I do appreciate what you all are attempting to do. With that said, you guys, it is refreshing to hear that someone, in response to, does this involve the consumer welfare standard, and someone, can't remember who said it, but said which one. I'm absolutely in agreement when it comes to, there's a lack of deny. I think many people can't deny that price is always sort of the focus on, at least a significant focus of any consumer welfare academic or view. However, you did raise that there are non-price features to the consumer welfare standard, and when it comes to free services online, like a Twitter or a Facebook, I don't think consumers are really that worried about, am I going to pay $5 for a tweet? It's more of the drove of data that they're going to have to give, or particularly with Facebook. Do you guys consider potentially looking at data as a form of currency, given that that seems to be the transaction that happens over these platforms? I, as a Facebook user or Instagram user, am giving a lot of data to Instagram or whatever, and in return, they are able to sell that data. So is there anything to that in sort of a consumer welfare type of analysis? Do your merger guidelines consider that in terms of, like, let's say Meta wants to merge with Twitter? Would the fact that they would get X amount of more data be at all relevant?
Yeah, such a thoughtful question. Let me start by saying the welfare of consumers is a really important objective of the antitrust laws. We're not writing that out. Nobody is. And a lot of antitrust can do a lot of things to protect the welfare of consumers, whether it's how much money they pay or how much data they have to give up. We have gone through painstaking detail to make sure we write these guidelines, that we recognize that competition can present in lots of different ways, and that whether it's the welfare of consumers, workers, or anyone else, can be threatened by excessive monopoly power. And so we have updated some of the even traditional tools around, for example, like one of the market definition tools, not the only one, but one of them is a small but significant non-transitory increase in price. Well, we say we should look at those price, but also in terms or quality, and or how much data that you're having to give up in exchange for product or service. These are economic realities. Like, we cannot deny them, and so we need to understand that that's how markets function, and make sure we're applying the law with a very realistic and accurate assessment of how markets present in today's economy.
Hi, I'm Alana Kowarski from MLEX Regulatory News Service, and I have two questions, but they are open-ended. So the first one is, how does the merger guideline revision complement the pre-merger notice form revision? How do you see those two as connected? And then the second is, what guiding principle did you use when you were figuring out which ideas from the comments and the RFI to incorporate into the guidelines?
Super thoughtful questions. I'm going to take the second one and reserve the first one for Jonathan. So in terms of comments that we got from the RFI process, you sort of read them, you engage with them, you think about sort of accounts of competition. And I think the benefit of them, when you can't investigate, you can't sort of evaluate sort of the veracity of what's being said. The value is always that it opens your mind to the different ways that people can be harmed by mergers. I think I went into the process believing that we had a pretty developed sense of the different ways that harm can manifest, but hearing it in people's voices based on their accounts, I think can be really powerful, and it can also help us calibrate how much weight or emphasis to put on particular kinds of harms. And so I thought, that was a huge benefit to us.
Yeah, I guess there's a process underway at the FTC which issued the draft notice regarding the HSR form with our concurrence, and I want to respect that process and allow it to play out. And so we're eager to see, I'm sure the FTC is as well, the comments that come back in return. I'll just say that, more information or better information on the front end will allow us to do our jobs more precisely and more efficiently and use taxpayer resources better. So I think a lot of antitrust lawyers in the private bar will tell you that the HSR form probably has, as it exists today, probably has very little relevance to a lot of the core questions that are being asked in an antitrust analysis. And so I think trying to harmonize the form with the actual questions that we're empowered to answer is a healthy, worthwhile exercise. And again, I will leave it to the public comment process and to determine whether the revisions got that right or not, or whether changes need to be made. But I do think it's a healthy thing to do, and I think privately, even most private antitrust lawyers will tell you that the form is largely out of step with the actual elements of the analysis.
I think we have time for one more. And I think
Let me
we only
also
have-
say, are there
please.
other law students in the room? I just want to make
Yeah,
sure
one back there.
if there are any law students.
Raise your hand high. There you go.
Yeah, if there are any other law students in the room who want to ask questions,
Yeah, absolutely, of
we
course.
will go longer because I think
our time is your time, or your time is our time.
So I want to make
don't
sure
know.
all the students get
Yes.
an
I know,
opportunity.
Because
to
that
ask
could be the
questions.
Now you
former
have to ask a question.
Yeah. Okay. So you go first, and then
Yeah.
and then
Well,
yeah.
Hi, I'm Alex Wilt. I'm with Connecticut Financial News. And so I was wondering, by stressing that the guidelines are grounded in existing case law and law, is it kind of prepping for convincing the courts to adopt these as a persuasive authority? And second question, sorry, there's two. So you mentioned how a lot of the comments that you got were about how people had been affected by a transaction rather than one that was taking place or proposed. Do you see a possibility that there could be a switch to look at more consummated transactions somehow? Because like a lot of vertical merger losses, and the FTC kept losing hospital merger cases, and they ended up winning by bringing a consummated hospital merger challenge. So, is there a way? Yeah, that's our question.
Sure. Do you want to?
Todd,
No, I was just remembering when I was at the FTC during the Bush administration, there were all these you mentioned hospital mergers and kept bringing hospital merger challenges and losing. So, so I remember that well.
They lost 9 in a row, but then
Yeah,
they
right.
got it right. Got it right. No, I'm not making fun of that, right? I mean,
No,
I
right.
think hospital mergers can be hugely harmful, and really we owe a lot to the FTC under the Bush administration, the Obama administration, for really trying to get that analysis just right.
What was the first question?
Can you repeat?
Yeah,
the
can you read the first
I'm so
question?
sorry.
The first question was, by stressing that this is like the guidelines are grounded in existing.
Yeah, I think this isn't, the document isn't tactical in nature. It's just designed to understand and develop an agency practice that reflects the state of the law as written by Congress and interpreted by courts. And inevitably, most cases will come down to the facts of a particular case. And we do have a system which I think, we all, love and respect, which is that if we have to bring it before a court, we have an independent judiciary that's going to make an assessment about whether we get it right or not. I think the more we are following the law, I think the more likely it is that we will build a case or bring a case that reflects the law, and hopefully as courts will see it. And so it's really a discipline, it's our burden in a case, and we have to bring a case in a way that is consistent with applicable legal principles, and that's really the objective here, and that's what we're trying to do.
I veered us off course in answering about the FTC. She had also asked, just to follow up on her question, which is, to what extent should the public consider this as a potential guide to challenging consummated mergers, I think was her question. She was using the hospital mergers as an example.
I deliberately...
They failed to do
No, I remember the question.
Okay,
I just
all right.
deliberately didn't
All right.
answer it.
Do we have any more law students? No.
Yeah. Yes. Well, anyone else want to go to law school?
Yeah.
Nothing has changed, right? The law hasn't. I'm going to be very, like Doha mentioned before. The law is still the law. The cases are still the cases. Nothing has changed, right? What we're trying to do is reflect agency practice in a coherent way, and apply and provide greater awareness and transparency about how we go about enforcing the law, and to do so faithfully. And that hasn't changed.
Hi, my name's Jack Altman. I'd be really interested to hear, particularly in the realm of vertical mergers, how DOJ incorporated the lessons learned from cases that it's lost in the development of the guidelines. So thinking back to either Microsoft Activision or AT&T Time Warner, and how those have been incorporated.
Yeah, great question. Where are you, law school?
Columbia.
Okay, great. Well, thanks for being here. Appreciate it. So I would say that, and Doha, you should weigh in as well. I think one of the things that we're trying to identify with these guidelines is that not everything neatly presents always as vertical or horizontal, right? I think a lot of vertical case law was developed around a very formalistic view of how markets function with manufacturers, distributors, and retailers, and kind of very linear or rigid supply chains. I think increasingly the market characteristics we're confronting on a daily basis are often multi-sided and multidimensional and present challenges that perhaps are distinct from that linear structure, or that rigid structure rather, that is, might be, more suitable to an incentive and ability or into a foreclosure analysis. Now that might be relevant in some other kinds of non-horizontal mergers, but I think what we've tried to do with the guidelines is recognize that there are a lot of different geometries that exist in the marketplace. I often like to say many of them are, less vertical and horizontal, more like a gemstone. And I think we have to be, aware that multidimensional nature of how markets function is a market reality that we have to take under advisement and into account as we investigate to determine whether competition is harmed or whether a merger may substantially lessen competition or tend to create a monopoly. And so we've really tried, hard using, rigor and applying the case law, which does speak to a lot of this, right? If you entrench monopoly power, right, that's a principle that it was established decades ago, but, can't apply today. Or if it accelerates trends toward concentration. Like those are, again, core concepts that speak directly to the intent of the statute and to the language of the statute.
Unsurprisingly, I agree with all of those things. On the subject of losses, look, we learn a lot from our losses. We own our losses. I think that being very reflective about, the opinions of courts and sometimes juries helps us get better. We get a better sense of what judges are asking of us, what kind of evidence is persuasive, how we're applying facts to the law and so forth. And so, we never bring a case unless we believe that a violation of law has taken place. Every single time we're doing a very sober application of the facts to the law. And while we always want to win, we don't always win. But we always take what we can from losses and try to get better the next time.
The point Jonathan made is one I want to make sure doesn't get lost, because I do think it's important, this vertical horizontal thing. And I hadn't really thought about it very much, so I was reading it and talking with him. That's just kind of pulled out of the air, right? I mean, I don't see that in the Clayton Act, you know.
The horizontal verger thing.
Yeah, right. All this sort of stuff, right? I mean, it's like, and you know, if I put on my legal realism hat again, I think may be, and I tend to agree with Jonathan, that may be a binary distinction that's outlived its usefulness. My sense is maybe that was one of those things back when we had all these goofy per se rules and stuff back in the olden days, right? It was a way of overruling precedent without overruling precedent to some extent, right? Kind of cabining off these sort of per se rules and that sort of thing. So we came up with these sort of rubrics to say, well, it's not that, and so, you know, we can do this and that sort of thing. And I think maybe that's as Jonathan says, I think a case could be made. That is a rubric that has outlived its usefulness and didn't have much of a statutory or logical basis to begin with. It was a useful presumption, but I think as Jonathan said, the world is much more complicated now. We realize that they don't fit neatly into those two holes, and so maybe it's time to kind of move beyond that. Maybe that was something that was useful in its day, but may have outlived its usefulness at this point. So.
Unless there are any more law students, I think we're done. Yes? Any final comments? All right. Well, thank you, everyone.
Thank you for having us.
Yeah.
Thank you.
Oh, Alita. Yes.
I just want to thank the audience for being very good at hitting like the register button quickly. This event sold out very quickly, and you have good reflexes, if nothing else, and also showed up and asked great questions, and we really appreciate the engagement on this. There's lots of people watching on live stream as well, and we appreciate them also, and all of them can send emails and questions to the general email box, which is info@fedsoc.org. I also do want to thank our panelists here for a really interesting and thoughtful and somewhat surprising conversation. I think it's it is in the sort of the best spirit of the Federalist Society to have surprises in our conversation. As always, speakers at Federalist Society events are speaking for themselves and do not reflect the position of the Federalist Society. And with that, I just want to invite the audience to join me in thanking our panelists, and we're adjourned.